Hi, my name is David Holt. I'm the Research and Emerging Technologies Law Librarian here at the Heaphy Law Library. This is the screencast on Introduction to Secondary Sources. We start this screencast with a definition as to what constitutes a secondary source. Secondary sources are materials written by scholars, practitioners that help explain and or analyze the law. They are distinct from primary sources, which include your cases, statutes, treaties, and regulations, as they are analysis of the law rather than the law itself. The reasons why we would use a secondary source include that they are easier to use and read, that they may save us research time as they have already collated and aggregated our primary materials together. They may discuss the development of a legal issue, and unlike a number of primary materials, they are frequently updated as they are published by commercial publishers that have a revenue stream involved in their publication. Some of the major types of secondary sources that you will encounter in legal practice will include treatises. Treatises, unlike horn books, are going to be a substantive analysis of a particular area of law that's intended for legal practitioners. A horn book is similar to a treatise in that it is a substantive analysis of a particular subject, but its audience is it's designed for law students rather than for legal practitioners. Some examples of major treatises that you will encounter in practice include Nimmer on copyright, Chisholm on patents, Farnsworth on contracts, Couch on insurance. They're frequently named after their original author, and that title tends to remain static even after that original author is no longer contributing to the treatise. And so you may find some treatises that are still named after original author who has not contributed to the treatise for a number of years or who has even passed away. After treatises, there is legal reviews, law reviews, and journals. This is our legal source of legal scholarship. There's a wide array of legal scholarship available. Again, I mentioned in a previous screencast that articles written by tenured faculty are going to be considered much more persuasive than student-written notes and comments, and there's a wide array of authoritativeness even among the journals themselves. The Harvard Law Review and Yale's Law Journal, for example, are going to be considered far more authoritative and persuasive than law reviews published by a lower-ranked law school. And we even have primary and secondary law reviews published by law schools. And so the flagship law review from Harvard, for example, is the Harvard Law Review. There's a number of secondary law reviews that are also published by Harvard, as there are with other law schools, that may be considered less persuasive than their flagship law review. Legal encyclopedias will include our national encyclopedias, which we have two. There's AmJur, American Jurisprudence, and Corpus Juris Secundum, also abbreviated as CJS. California is unique in that we're a large enough state to have our own state encyclopedia, and that is called California Jurisprudence, or CalJur. American Law Reports is a national secondary source. It's considered more substantive than an encyclopedia entry. It is national, so it will include both federal and state legal topics, with the exception of ALR Fed, which, as the name would imply, is exclusively federal legal materials. Restatements are a restatement of the majority rule within a common law area as adopted by the states. We're going to go into that in a little bit further into the screencast. There's also bar journals and newsletters, which you may not have encountered so far in law school. Many state bar associations will publish their own journals, and a number of ABA committees also publish their own newsletter services. Practice materials, as the name implies, are materials that are designed for practice. We have just a handful of major publishers that tend to dominate this market. In California, the three big publishers of practice materials are Rutter Group, CEB, and Matthew Bender. Rudder Group is licensed by Westlaw, and so you will be able to access Rudder Group practice materials on Westlaw. Matthew Bender is wholly owned by Lexis, and so you will be able to access those materials on Lexis's platform. CEB is a little unusual. It's owned by the University of California, and it has its own electronic platform. You won't be able to access CEB materials electronically through either Westlaw or Lexis. B&A is a publisher of practice materials, as is CCH. They tend to focus on federal legal topics with a particular focus on securities, insurance, labor and employment, and taxation. B&A materials are going to be available on Bloomberg's platform, as they have recently been acquired by Bloomberg. We also have litigation tools such as Amjur's Proof of Facts and etc. Forms, which we're going to spend an entire week on, and then uniform laws and model acts. The distinction between a uniform law and a model act: uniform laws are created to be adopted in whole cloth by state legislatures in areas of the law where uniformity would be desirable. And so if we can think of some examples of uniform laws that we've already encountered in law school, the big one, of course, would be the UCC, the Uniform Commercial Code. And yes, of course, that is an area of law where uniformity would be desirable, as we want business transactions to have uniformity across state lines. Some model acts that you've already encountered in law school. The Model Penal Code, of course, would be probably the most prominent of those. Model acts do not need to be adopted by state legislatures by whole cloth. It's not areas of law where uniformity is necessarily desirable. The purpose of a model act is to save time and effort so that a state legislature doesn't have to reinvent the wheel, essentially. Okay, let's dive into our major treatises here. First, let's talk a little about the legal history that's involved in the publication of legal treatises in the United States. For a very long part of our legal history, Blackstone's commentary on the laws of England was considered pretty much the Bible, and one of the only, if not the only, source of analysis of the British common law. It was originally published in 1765, and it was hugely influential in the development of our legal system. We didn't have other secondary materials developed in that covered American law for quite some time. If you look at legal scholarship, even from the turn of the century, you'll notice a number of articles will cite frequently to Blackstone, as there was no other authoritative secondary source available for commentary. Okay, how do we define a treatise? The definition of a treatise can be a little bit blurry. Generally, the term treatise will apply to a single or a multi-volume work that provides commentary on a discrete legal subject. It may be bound, or it may be published as a loose leaf. We do have loose leaf materials that are designed for practice, and so the demarcation between a loose leaf set designed for practice and a loose leaf set designed as a treatise is that a practice-oriented loose leaf set will include practice materials such as a newsletter service, sample forms, perhaps some primary materials, so a republication of statutes or relevant regulations, as opposed to a treatise which will not include those materials. Again, some notable treatises that you will need to memorize. Wright and Miller's on Federal Practice and Procedure is considered the Bible for federal practice. There's Chisholm on patents, Nimmer on copyrights, McCarthy on trademarks, Milgram's for licensing, Farnsworth, Prosser on torts. Collier on bankruptcy is considered a Bible for bankruptcy practice. And here are some list of legal treatises by subject. Harvard Law Review has a list that's fairly exhaustive. And it has these organized alphabetically. If you go in, for example, under patents here, or intellectual property rather, you'll see that it lists Nimmer on copyright as a major treatise for copyright, Chisholm on patents. Chisholm on patents is available on Lexis, and the equivalent that's available on Westlaw is called Moyes-Walker on patents. McCarthy on trademarks, again, it's considered the Bible for trademark law. Okay, some of the strengths and weaknesses of treatises. Treatises are considered rather authoritative, especially when a court is dealing with a nascent or emerging legal issue in which there is not case law already published. The authoritativeness of treatises, however, varies widely. They can be fairly comprehensive. Big disadvantage here is that there is not a free alternative. You either must use the treatise in print or you must use a licensed database. And if you do use an electronic database such as Lexis, Westlaw, or Bloomberg, the cost for accessing a treatise is rather high. Generally, to access a single entry in a treatise will run from $80 to $120 for the retail price on Lexis or Westlaw if the treatise is not included in your base plan. A strength is that it includes annotations to both primary and secondary sources. It's updated frequently, but again, it can be difficult to assess. And your firm may not have access. Vendors, this is a big issue. Vendors don't license this content to each other. And so if you have a need to locate an entry in Chisholm on patents, for example, and your firm does not have a subscription to Lexis, you're going to be paying the highest cost to access that, the full retail price. Okay, introduction to legal scholarship. Legal scholarship is a little strange for a number of reasons. For one, most academic scholarship is peer edited. Legal scholarship is not. We have this very bizarre student-run method for the selection and publication of legal scholarship. Another oddity with legal scholarship is that there is no revenue stream with legal scholarship. We don't have any commercial publishers that are involved in this process. Legal scholarship overwhelmingly is published by law schools themselves, so there's no profit stream. Student work frequently gets published. This is very different compared with other academic disciplines where student work is very rarely, if ever, published. It's often used as a means to acquire tenure. We should be honest and upfront about that. And its value has been in decline for over 20 years now. The number of citations to legal scholarship, although there's some dispute over this number, I think it's pretty persuasive that the number of citations court opinions have to legal scholarship have been in decline. This is the famous quote from Justice Roberts that's received a lot of criticism, of course, within the legal education market, but there is some truth, I believe, to this, that it may be of great interest to the academic that wrote it, but isn't of much help to the bar. So the actual value of legal scholarship. Why am I even going over this on the screencast for secondary materials? Well, it's much more likely to be bleeding edge than other secondary materials. And so if you have a very new, novel, nascent and emerging legal concept or issue, legal scholarship may be a great source for commentary and analysis on that. Also, they tend to be very narrowly focused, and so if you do have a fact pattern that was taken up by a law review article, that may be an invaluable source for you. Okay, bar journals are periodicals published by state or local bar associations. State bar journals are more prominent in the smaller states than they are in California, and the reason for that is because we have so many law schools here in California. The ABA does have its own bar journal called the ABA Journal. It also has a number of journals and newsletters that are published by their committees. These tend to be more practice-oriented, more practical than many of the topics that are going to be taken up in student-edited law reviews. Okay, introduction to encyclopedias. We're rather unique in California in that we also, in addition to our state encyclopedia, have a set of Wittken's encyclopedias. There are actually 4 sets of Wittken's. You've gone over this a little bit in your first year of law raw. There's California criminal law, there's California evidence procedure, and then the summary of California law, which covers all of your civil actions. California jurisprudence is our state encyclopedia. AmJur and CJS are our national encyclopedias. They're going to include references to both federal and state law. AmJur is considerably more relevant than CJS. CJS is considered rather antiquated at this point. Many law libraries, in fact, are discontinuing their subscriptions to CJS because it is infrequently used. American Law Reports is another odd one that is more substantive than what you'll find in an encyclopedia entry. They're not going to be comprehensive, but if you do find a relevant ALR entry, it will go into some detail. And there are 2 different types of series in ALR. There are ALR series 1 through 6, which is a national set, will include references to both state and federal legal materials and topics, and then there's an exclusively federal series that's simply called ALR Fed. Okay, restatements. This is a topic of confusion for a number of law students as to what really is a restatement. You probably encountered references to restatements in your contracts and or torts course during your first year. Think of a restatement simply as a distillation of the common law. It's essentially the majority rule held by state courts on a particular topic, and so it's really a restatement of the existing common law rule. Even though they are a secondary source, restatements are highly respected by the courts. And again, this is only going to be on those causes of action that are based in the common law. If you have a statutory cause of action, the value of a restatement is going to obviously be much lower. Restatements are created by the ALI, which is also the body which creates a number of the uniform laws and model acts. Model acts, there's also an organization, it's a consortium of the state legislatures that convene together to create model and uniform laws. Here are a list of the subjects that are currently published as restatements. And then we get into uniform laws and model acts. Again, like I said earlier, the most successful uniform law by far is the Uniform Commercial Code. And the purpose of a uniform law is to propose a statute to be adopted by whole cloth by state legislatures in an area of law where uniformity would be desirable. So we can think of areas of commercial law. That's an area where uniformity would be desirable. What are some other areas that we can think of? Probate law would be another area. We want expectations for people who own real property in more than one state to be as easy and straightforward as possible, and so the probate process would be another area where the uniformity would be desirable and a uniform law would be effective. Model acts are similar in that they are to be adopted by state legislatures, but they're in areas of law where uniformity is not necessarily the goal. And the most popular model act that you will encounter is the Model Penal Code. There's also the Model Act for Legal Ethics, which California is unusual in that we haven't adopted either of those model acts. How would you use a model act or a uniform law? A court really won't have any reason to cite to these. It may be instructive, however, if the state has deviated from the uniform law, to cite to the uniform law to explain why the state made the deviation, or it may be useful to cite to the model or uniform law to demonstrate what were the public policy goals that were intended.